Perfect. Hello, everyone. I'm just going to wait a couple more minutes and then get started. While we wait for the others to join, maybe you guys could share what city you're in right now. That'd be interesting to know. Ooh, nice. We have someone in Ulm. Ah, someone's even on a train. Berlin, nice. Ooh, we have a couple of people from Berlin. Amazing. Italy, Oslo, Hamburg. Wow. Amsterdam. With quite a lot of people from Berlin. Amazing. All right, then I'd suggest we just dive right into it. So, welcome everyone to our webinar on the AI Act. My name is Deborah, and I'm going to be your host today. We have a great and informative session planned with Philip, who is our expert on all things AI. So he's going to guide us through the AI Act and give us some insights and practical advice. So enjoy the session. If you have any questions throughout the presentation, please write it into the questions chat and we will answer them right after the presentation. So Philip, over to you.
Yeah, first of all, thanks guys for coming to this talk. I'm really glad talking about this regulation. I think it's going to affect a lot of companies in the future, in the near future actually. And I feel like in the public communication so far, nobody's really going into specifics, right? Like a lot of people talk about the AI Act in general, about the different risk levels, but there's very few who actually tell your company how you should prepare. And I think that's because a lot of professionals, even in the legal business, don't actually know what's coming. And so we want to address that. So first about me, I studied law. I did my first state exam in 2020 at the Serious Law School in Hamburg. After that, I studied computer science at the University of Hamburg with a special focus on artificial intelligence and natural language processing. And I've been actually researching the AI Act for about 1.5 years now. And so in the beginning of 2024, I joined Heider to develop a new compliance platform specifically for the AI Act and to just apply the knowledge that I already had about the regulation in a professional setting. So let me just briefly introduce our company. We were founded in 2020. Our headquarters is in Berlin. We have, by now, we are like growing pretty fast right now. We have over 50 employees from all kinds of different nationalities and backgrounds. We have over 1,000 customers and do about 10,000 consultations yearly with all our customers. So what even is the AI Act, right? It's a EU legislation that is meant to regulate AI in a comprehensive manner. That means it was passed by EU institutions and not by national governments. However, being a regulation, it's directly applicable in all EU member states. That means it's just the same kind of binding law as if any kind of national government would have passed this. Also, it is it has an actual impact on your company. So if you don't comply with the law, it isn't just it's something you should care about, right? Like you can have fines up to 35 million euro or up to 7% of annual revenue. And the past has shown that the EU regulatory authorities are usually not shy to apply these fines even to big companies if you don't comply with their regulations. So let's first talk a bit about the timeline. So the AI Act was passed a couple of months ago, and it actually will become binding law this month. That doesn't mean, however, that it's all its parts will apply immediately. So in 6 months, the ban of the most risky systems, and I will talk about those in more detail later, will come into effect. Then in June 2025, so exactly in 1 year, the full law will enter into effect, except for the rules for high-risk systems, which will only take effect in June of 2027. So in 3 years. So it does seem like, well, we still have time, right? But you have to remember that in 3 years, you will have to be done with your compliance process, right? So all of these measures, which I will talk about later, will have to be implemented by that point. So you should really start thinking about it now, because if you only think about it in 2 years, you're going to be late and you do run the risk of getting fined because of it. So why is the AI Act important? You might have, on the picture, you can see a new iPhone with the USB-C port. Some of you might have that already. That was due to an EU regulation. And we've seen that in the past, in many cases, that EU regulation actually sets global standards. And that is because the EU, as a governing bloc, is actually one of the only governing blocs worldwide which actually tackles these sort of tech problems and tries to regulate tech companies and emerging technologies of the future. So specifically for AI, you don't see any other competing frameworks in other regions which holistically and in a binding manner tackle the whole question of AI compliance. So I think what will most likely happen is that the AI Act will also set global standards just because of the importance of the EU market. And you've seen this before with Apple, who now reacted with their flagship product to an EU regulation, even though they are an American company. Also, your customers are going to demand and expect fair and safe AI. And you've seen this in a bunch of industries in the past few years. So just one example is the push to introduce fair labels for categories like produce or coffee. With the fair trade label, people increasingly demand that their products are not just good, but also sourced in a fair and ethical way. And the same thing is going to happen with AI. So in a couple of years, your customers won't just use any AI, they will also expect that it's done the right way. And the same goes for investors, right? If you go to an investor meeting and your investors see that you haven't even thought about this topic and there's no action plan of how you get compliant with this regulation, that will make them very concerned. So investors generally only support compliant companies. And if you're thinking about developing or using AI, you will have to be in compliance with the AI Act. So you will have to show a strategy for that to your investors. So let's start talking about the actual regulation. So you might have seen this graphic before. What is it actually about? So it is about the different risk levels in the EU AI Act. And let me just start out by saying that AI is always risky, right? No matter what kind of AI you are using, there's always going to be certain risks associated with that. However, some AIs are obviously much more risky than others. And that's why the European Commission, when they envisioned the AI Act, started introducing these different risk levels. And they started at the top with unacceptable risk, with systems which are just illegal. And they go all the way to the bottom, to the minimal risk category, where there's no regulation at all. And originally, it was only supposed to be these 4 categories. But then in the end, in November of 2022, ChatGPT was introduced and just radically revolutionized how the public perceives AI and how AI is being used. So these systems like ChatGPT, or nowadays even Bard or Llama by Facebook, these are very general. They don't even have a specific use case. And so the European Commission had to invent a whole new category just for these systems. And that's the general purpose category. However, unless you are one of these big companies like Microsoft, Facebook, and so on, who develops these very general and far-reaching general purpose AIs, you won't have to worry about this category, as it only applies to developers of these systems. So I'm going to focus on the other 4 in this presentation, and I just want to start at the top with the unacceptable risk systems, since they are going to take effect first in just 6 months. So what are unacceptable risk systems? Unacceptable risk systems are so dangerous that they will not be allowed. They will just be banned outright. And if you develop and then place on the market any system that falls into this category, regardless, you will be fined because of it. So you really have to understand the system, this category, and make sure your system doesn't fall into it. It is narrow, but it's still worth thinking about. So how does it work? Basically, you have these 6 categories, which we like broadly summarized here. And if your use case of your AI system falls into any of these categories, then it's going to be unacceptable risk. So let's just start going down the list, right? First, you have biometric categorization and real-time surveillance. That means cameras which process and surveil and process biometric information in real time in any public setting. Then next, you have stuff like emotion detection in the workplace. So think of a retail company which would monitor their workers to make sure they always interact with customers in a happy and nice way, right? That wouldn't be allowed. Also, just indiscriminate scraping for facial recognition databases. Crime prediction, which is something that's actually already being used by certain law enforcement agencies in the US. Social scoring, that is something which is already being implemented by the Chinese Communist Party, right? And then also exploitation and manipulation of people to cause harm in a subliminal way. So think of systems which try to influence people without them even noticing for some gain for your company, which is harmful to them. That also would be unacceptable. And so I think a through line that you can see with these systems is that whenever you have a system that is intentionally malicious and you just don't care about it and that will cause harm to people, it will likely be seen as unacceptable risk. And I think personally that will even apply to systems which don't neatly fit into any of these categories. As long as they are malicious and harmful, regulatory authorities will find a way to put you in one of these buckets, because that's basically what this category is for, right? We don't want people to put malicious AI on the market. We want good faith actors. And so just if you think about doing that, probably rather just don't. So next, let's jump to the bottom of the pyramid. What are minimal risk systems? So minimal risk systems are really systems which are only risky because they are AI, but their use case is so benign that we don't really care about them, right? I mean, think about something like jaywalking. It's technically illegal or frowned upon, but if nobody's there and you take care about it, we don't really have to put rules down because of it, right? So what are minimal risk systems? Think of spam filters, think of computer games. So maybe you have some sort of RPG and you want automated dialogue. That could be a minimal risk AI. And also other strictly creative applications. So maybe you want to develop an app that helps people with script writing, or maybe you want to develop an app that uses AI to help people paint, stuff like that is really something that the regulatory authorities don't really care about. So let's work our way back up the pyramid. The next risk category that we have to talk about are limited risk systems. And these are systems where the EU Commission really just cares about you being transparent. They want transparency from your system. They just want you to show and tell people that you're using AI, but you really don't need anything else beyond that. So what kinds of AI are we talking about? First of all, generative AI that can create any kinds of media that could serve as deepfakes. So pictures, audio, video. Maybe you've seen this picture of Pope Francis, which went around the internet recently. That was actually a deepfake, but it looked very realistic, and there was a lot of buzz and talk about it, even in serious media, before that was debunked. And so, in order to combat that, for generative AI systems, your output will have to be labeled as such. And then secondly, conversational AI. So think about chatbots or customer support bots. the EU Commission really wants you to be transparent about when AI interacts with human customers. So you can't have some customer service AI which pretends to be human but really isn't. You need to be transparent about that. And then lastly, high-risk systems. So high-risk systems are really the focal point of this whole regulation. High-risk systems are systems which are so important for our economic development that we do not want to outright ban them, but so risky that they need to be accompanied by a bunch of regulation. And so if you look at the AI Act, a large percentage of all regulation that's in there is just about high-risk systems. And they lay down this whole regulatory system, and it's only for these use cases. And it's also like just like the unacceptable risk category, it's a bunch of categories. And if your system has any use cases that fall into these categories, you're going to be high risk. You can be in multiple categories at once, and that will affect your later compliance duties in order to get compliant. But in general, it works in a way that you just go down the list and see if any of your use cases apply to this. And it's important to remember that this list isn't static. So it's not in the actual law itself, but it's in the annex. And this annex can be changed by the European Commission. So without even consulting all the national governments, the EU Commission can quickly react to future market developments. So if they see that some sort of new use case comes up, which they see as especially risky to fundamental rights, they might add or modify an existing category. So if you look at these categories, one through line that again you can see here is that all of these categories have a close connection to our fundamental rights in some respect. So let's look at the first one, usage in critical infrastructure. That's fundamentally about safety, right? We want our power grid to be safe. We want our water supply to be safe. And for all of these systems, AI will probably be used in the future, but it should be especially robust to cyber attacks or other malicious actors in order for our functioning as a society. The same goes for the next few categories. So access to education, the workplace, or essential services. That's fundamentally about personal freedom and access to economic opportunities. Migration, asylum, and border control. That's fundamentally about human dignity, which is also protected, right? Then justice system and the democratic process. That is about our government, our democracy, our whole system as a society. So obviously that's very sensitive too. So lastly, I want to talk about what you actually need to do as a company to get compliant. And this is difficult. I won't be able to cover each and every subject here, but a lot of people try to not talk about it in the first place. So I want to try to at least touch on it. So first of all, the AI Act differentiates between different types of actors. And depending on what type of relationship you have with your system, your compliance duties are also going to be different. So the first categories are providers. Providers are basically developers. They make the system and they later market. Then we have deployers, and deployers are basically users. So don't think of consumers, but companies which buy AI systems. Individuals is really not what this regulation is about. But if, as a business, you just buy some AI and you put it into service, you're going to be a deployer. And then lastly, we have importers and distributors. And these are really just intermediaries. These are companies which only trade with AI, but who neither develop or use them themselves. But it's important to know that if you make substantial changes to a system or you put your own brand on it, then you can also, just by doing that, become a provider yourself. So think, you might be a company that buys some sort of stock AI and you customize it according to your personal needs. Then you become a developer. And you can also become a combination of these roles. So again, you buy some stock AI, you modify it, you become a provider, then you put it into service. Now you're also a deployer. So you have to be in compliance with both regulation for providers and deployers. And if you later sell your modified AI, you will also become a distributor. So you will have to take care of that too. But the main ones here, and I think the most important ones for most of you guys, are going to be the providers and the deployers. So that's what I'm talking about for the last chapter here. So first of all, let's again start from the bottom. For limited risk systems, there's no regulation, right? For unacceptable risk systems, you don't really need to think about regulation because your system is going to be illegal anyways. So the only way to get compliant is to get out of that category. However, what about limited risk systems? Like I already said, you only really care about being transparent. So for providers, you need to inform your users that they are interacting with AI, if it's some sort of chatbot or other AI that interacts with customers. So that could be done in a way where the AI in its first message always is transparent about, hey, I'm an AI chatbot, I'm not a human, how can I help you? Something like that. Then secondly, if your AI is generative, so if it can generate pictures or other forms of media, that AI content will have to be marked in a machine readable form so that machines can detect its AI. And if you're a deployer, you will have to mark your content that you generate with your AI as artificially generated so that humans can detect that it was made by AI. And really the purpose here is, again, to just provide transparency. So next, let's talk about high-risk systems. And for high-risk systems, again, there's a lot of differences between providers and deployers. And actually for providers and deployers both, there's a further differentiation between compliance duties that relate to your system and compliance duties which relate to your company. So let's talk about system-related compliance duties first. These are really compliance duties which affect your code and the AI itself, right? They don't affect your corporate structure around it, but they affect how you develop and design your AI. And unless you want to hear me talk about for another hour, I won't be able to cover them all, but I want to briefly talk about the first two. So the risk management system. Let's say you develop an AI that is made for doing hiring decisions. What is the typical risk that is associated with hiring decisions? So research has shown that these systems typically are biased towards people who you have hired in the past. So that is a typical risk which is associated with your use case category HR, or access to employment. So you will have to take care of that risk. You will have to implement risk management measures. So for example, a compliance officer or a strategy, how to mitigate that, or a detection system which will notice these biases and will make steps to address them. And you will have to document and show that you've taken these steps, right? Because whenever some regulatory authority comes around and audits your company, it won't just be enough to say, yeah, I'm doing this. You will have to provide documentation for that. In the same way, your data and data governance system will need to make sure that your training data is actually representative for the people you are going to use your system on. So in this hiring example, your training data set can't just be your past hiring decisions, but it will have to represent the entire pool that you're actually hiring from. And then for compliance duties, for company-related compliance duties, these really address your corporate structure. So on a policy level, you will have to implement measures which will make sure that all these system-related compliance duties will not just maybe be implemented, but will definitely be implemented. And that's your quality management system. And again, to be able to prove and argue that you've taken these steps. So you will need to have it in writing or in corporate decisions. And then also, and that actually goes for all kinds of companies which use AI. So not just for high-risk systems, but whenever you interact with AI, you will need to make sure that your employees have the appropriate level of AI literacy. So they will actually need to be educated what the risks that might result from your system actually are, right? You can't just hire anybody and let them use your system without any training. But you as a company will have to make sure they're sufficiently trained. And again, you will have to prove and document those trainings. And then lastly, from Article 40 onwards, you have these different procedures that deal with registering your AI. So you will have to undergo conformity assessment procedure. Then you will have to declare you're actually in compliance, and you're liable for that if you're not. And then you will have to register your AI in a special EU database and continually monitor it post-market once you've placed it there. So let's talk about compliance duties for deployers of high-risk systems. So as you can see, there's not a lot of duties which are system related. Basically, you will just have to make sure that you use the AI in a way that enables human oversight, so that humans can still see and understand what your AI is doing. And then on a company level, again, you will have to educate your staff so they know how to use the AI in the right way. And then other than that, you will mainly need to make sure that you use the AI in accordance with its instructions that are provided by the provider. And you will have to make sure that only relevant input data is being used. So even if the system is good, you as a user still have to make sure that you feed it with the right data, right? Because usually if you input bad data into your system, the output will also be bad data, and that might cause you to not be in compliance with the regulation. As a user, you will also have to market your system once you put it on the monitor your system once you put it on the market. And actually, you have specific duties under the GDPR too to conduct a data protection impact assessment about the input data that is being used in your company. So what if you are not interacting with high-risk systems at all? You might think, well, my company is just using ChatGPT, and you just told me, well, it's a general purpose AI, and so it's not high risk, and there's really not that many compliance duties at all. Or maybe you're minimal risk, or you think you're just limited risk. Regardless, even if your whole AI use case in general seems to be low risk, you still need to document that. You still need to classify your system. You still need to be able to prove that you're just a deployer and not a provider, that you don't make substantial system changes to the system. And if your company is going to be audited at some point, it won't be enough to say, hey, I'm just low risk. You will have to be able to argue why you are low risk. And that is why it's important that even if you're not in the high risk category, you conduct at least a basic compliance audit in the first place. So finally, let's talk about cost. So this table is pretty confusing, and I took it directly from the market impact assessment by the European Commission. So whenever the European Commission thinks about a new compliance regulation, they conduct these impact assessments. And they are really, the purpose here is to assess how expensive these regulations will be for small and medium companies on a per year basis. So, I mean, this is, if we're talking about, like, this table talks about providers of high-risk systems, and that is the most difficult category. But still, you can see there's a bunch of one-off expenses for just basic compliance, then for verification of that compliance, and then also a bunch of recurring expenses. And so in total, the European Commission estimates that you will have, as a provider of a high-risk system, compliance costs about 30,000 bucks a year. And it will be less if you're just a deployer and not a provider, and if your system is not high risk, but maybe just limited risk, or you're just trying to prove that you are no risk at all. But still, these compliance costs will be significant. So I think it's doable to do it yourself, but it might just be simpler to let somebody else do it. And that's why, in the end, just briefly, I want to let you know we are currently developing a new product. We are going to beta test next year, and our compliance costs will start at 200 a year. So we are really trying to operationalize this regulation and make it easier for companies to be in compliance with that. So finally, if you want to learn more about the AI Act or us in general, please feel free to contact me on LinkedIn or visit our website. I'm always open to chat. And yeah, other than that, thank you for your attention, and I'm happy to take any questions.
Amazing. Thank you. Philip, we actually have one question. And someone asked, is the high risk social scoring related only to political topics or also to businesses like a customer or prospect scoring?
So the social scoring is really something. It's not the same as credit scoring, right? If you are doing credit scoring, that would most likely fall under the essential services category. So you can view credit scoring as an essential service to have access to credit, and credit is a really important part of our economic system. So that will likely fall under that. Credit scoring will not suddenly be illegal, even if it's done with AI. Social scoring really means that every aspect or a large part of your social life or online activity will be monitored and then scored and reviewed by some government entity. So with the system that was a couple of years ago implemented by the Chinese Communist Party, you can see that your whole online activity is being tracked, and whenever you do something that's undesirable, that will affect your social score, and your social score will then affect stuff like employment opportunities, education opportunities. So it gets really sinister really fast with these kind of unacceptable risk categories, and you can usually see the maliciousness there, right? Like that in general just doesn't seem to comply with our understanding of fundamental rights. So I would say usually with these categories, there should be some sort of feeling there, right? Like if you are unacceptable risk, you usually have a bad feeling beforehand, and you can sort of know. You know what I mean?
Perfect. Thank you. Another one is many law professionals have doubt that services like ChatGPT fall in the regulation due to higher requirements of the AI definition, according to Article 3.1, and etc.
Yeah. So I haven't read the article that you've just linked, and I can't read it on the fly. Um, I'm very certain that ChatGPT will be under the general purpose category, and that's mainly because the category was invented for ChatGPT in the first place. So if you look at the categorization requirements, they definitely apply to ChatGPT. And if you're talking about the basic definition of AI, I'm certain that ChatGPT falls under that. And if you want to, you can like message me on LinkedIn and we can argue about specifics. Um, I can't go, like I said, I can't go into detail on what you've just linked. Um, but I would be very surprised if systems like ChatGPT find a way around this regulation. And personally, I think that the definition applies. I have no doubt about that.
Amazing. One last question is we don't think we are in any of these categories that were named. Does that mean that we can just ignore the AI Act?
Yeah. So I mean, I've already briefly addressed that in the talk, but I think just like with data protection compliance, it's important to show that you've thought about this as a company. Like if you're a small company, the regulatory authorities are not going to expect you to have a whole compliance department or have this huge process. But you're, especially if you're actually low risk and you think this regulation doesn't affect you, but you should at least have some sort of documentation and some way to argue why you think you're low risk. So yeah, put that into writing, consult somebody, um, really try to understand the act and then argue in a fair and objective way why you think it shouldn't apply to you, right?
Perfect. Mm. There aren't any more questions. So with that being said, thank you, Philip, and thank you everyone for your questions and for joining. We really hope that you were able to gain some valuable insights. If you do, like Philip mentioned, have further questions, feel free to reach out to Philip directly or to our
Yeah.
team. But other than that, have a great day and thank you for joining. And until next
And
time.
just one more thing before we leave. We actually prepared a cheat sheet with all the relevant information about this presentation. So I think you will get that per email.
Yes.
So yeah, if you want to look it up, just look at our cheat sheet. If you have further questions, don't hesitate to contact me. All right.
Perfect.
Thank you.